9:38 to the Big 550 KTRS. He's the second best talk show host in the country, or in the state. So says the Missouri Broadcasters Association. And he's our friend. Excuse me if I'm a little shy.
They're never wrong.
I'm a little shy around you, just because you've reached legendary status.
That's right.
Now, on Monday, I guess, right? June is, or earlier in the week, I guess. June is the month in which the Supreme Court decisions start to trickle out, right?
Yeah. This is the hot topic month for the big
And
decision.
the culmination might be this gay marriage decision, which will probably come at the end of the month.
Just like Obamacare was the last day, I suspect that the gay marriage stuff will be the last.
Well, the first one was this DNA case in which, if I have my facts correctly, the cops, thanks to this 5-4 decision by the Supreme Court, the cops now have the right, when they arrest you, to automatically take your DNA, and you have no say in the matter.
It's pretty much right. There was a gentleman in Maryland who was arrested on what they consider a serious felony, rape, robbery, assault. It was an assault case. And as part of the arrest, the fingerprints, the mugshot, they took what's called a buccal swab, which is basically a Q-tip. They stuck it in his mouth, roll it around, and then they put it to a DNA database. Now, it only took them about 3 months to get it to the DNA database. And as it turns out, Mr. King, who was arrested not for a rape
He was
case,
innocent for the first arrest in which they took the DNA.
No, they got him on that. It was an assault.
Okay.
It was an assault case.
Oh, okay.
But it was completely unrelated to an old cold case rape from about 6 years earlier. When his DNA buccal swab went into the federal database, which has been in place for about 15 years or so, ding, there was a match from the DNA taken from an unsolved rape in a different county in Maryland. So now they've got King's DNA attached to an unsolved cold case crime. He is charged and convicted on the rape case, which he was never a suspect in, but for taking the DNA swab.
Love it. What's wrong with that?
Well, there's a little thing called the Fourth Amendment of the United States.
Schmorth.
Yeah, we don't care about these things, except for the fact that it's really important. It's the unlawful search and seizure statute. You have to get a warrant in order to get a search for certain kinds of evidence and certain kinds of crimes. And if there is no warrant required, the search that's done still has to be reasonable. So the Fourth Amendment is a fundamental constitutional right that applies to the states. The challenge by Mr. King, and the Court of Appeals in Maryland agreed with his position, is that this was an unreasonable search. You are intruding into my body. And, oh, by the way, in an argument he didn't really know at the time, just 6 weeks before this decision, the court in a case that started in Missouri called McNeely said that taking blood tests, taking a suspected drunk driver to a hospital and extracting his blood without a warrant was an unreasonable search. That was 8-1. Thank you, Clarence Thomas. He was the one.
Wait. The court ruled just a few weeks ago?
Yeah, in March. 6 weeks before this King case, in a Missouri case called McNeely, taking somebody's blood sample without a warrant is an unreasonable search.
So a few years ago, the Supreme Court ruled taking someone's blood is unreasonable and not allowed to do it.
That's right.
But taking somebody's DNA, according to this case, is.
That's right. And this is where the problem in the debate starts. A 5-4 court decision is usually decided by Anthony Kennedy.
Yeah.
Ask Justice Kennedy. And as it turns out, who writes the opinion for the majority in this case? Justice Kennedy. Now, the rationale for it is very interesting, but the lineup of who the five were is fascinating. It did include the usual suspects. Clarence Thomas. He thought taking blood without a search warrant was fine. And then
DNA.
Well, no, in the McNeely case.
Okay.
So you've got him, and you've got Roberts, you've got Alito. So you got the conservative bloc, and usually that would be Antonin Scalia. Well, he's not in this. One of the liberals, Stephen Breyer, is. This is the
Wait, back up a second. You confused me for a second.
Yeah, this is why I was second.
The court ruled that it's okay to take the DNA.
Okay to take the DNA swab in the mouth.
Okay.
Because.
No, hold on a second. Yeah. But who voted in favor of that? You're saying
Kennedy.
Roberts.
Kennedy.
Alito.
Thomas,
Thomas,
and Stephen Breyer.
He's a lib.
Considered to be the hardcore group of the liberals that you would think, oh, well, the civil libertarian, Stephen Breyer, he would think that this was unreasonable. After all, he was in the 8-person majority that said taking the blood without a warrant was unreasonable.
So he switched.
But he switched. So not only did Justice Scalia switch, and he wasn't with the majority, but Stephen Breyer, the liberal, switched, and he's with the, quote, conservatives. Here's why they said it's okay.
All right.
They said that this buccal swab, that this DNA, is not very intrusive. After all, it doesn't hurt very much.
Right.
Well, you're sticking something in somebody's mouth.
Well, it's for 2 seconds.
And it's only done for identification. Because what we want to do is make sure that we have the right guy. If we've arrested Mr. King and we're charging him with assault, which is what the original case was, we want to take his fingerprints, take his photograph, and we want to take his ID, but that's not good enough because he might be able to fool us. We still need more. What we want is his DNA. We want to make sure that we have the right guy. So if he gets out on bond or if he's processed, we don't have the wrong person. Now, here's why that's ridiculous. Because there are a variety, and I've just listed some of them, of ways to identify the subject that is in custody. This is not a way to identify the person.
How big of a problem is it arresting Scott Sherman, but the guy claims he's not Scott Sherman, and turns out he's not Scott Sherman?
Yeah, it's almost completely. It almost never happens.
It happened. I mean, it happened once with Ray Langford. That's it. I mean, that's really the only time it's happened.
And there's a fingerprint database now that's been electronically sort of hooked up. It takes about 27 minutes in order to check somebody's fingerprints and run it across to make sure that that's the person.
Okay.
So how long does it take to get the DNA? And this is where Justice Scalia, who wrote the minority opinion, the dissenting opinion,
so
went
Scalia
nuts.
was against
not only
this government intrusion of taking your DNA.
Not only was he against it, he excoriated the majority on it by saying, look, it took 4 months in King's case to get the buccal swab DNA to the national database because it sat around for 3 weeks in Maryland before anybody even sent it off. They didn't identify his DNA for over 4 months. And not only did they not identify his DNA, they sent it to the database that solves cold case crimes, which doesn't even have names attached to it. They didn't use this for identification.
Yeah.
They used it to solve cold cases, and that intrusion is unreasonable, and the manner in which the court rationalized this is wrong. And in his words, not mine, he said, solving unsolved crimes is a noble objective, but it occupies a lower place in the American pantheon of noble objectives than the protection of our people from suspicionless law enforcement searches. The Fourth Amendment must prevail. That is Antonin Scalia, civil libertarian, saying that DNA samples without warrants are unreasonable searches.
I would ask him.
The law.
I would ask him this question:
Yes.
When did taking DNA swabs become illegal?
When did it become illegal?
Yeah, according to him. Isn't that what he said in the whole?
And he goes into it. He says that this goes back to James Madison and the he's writing. He's the only one that knows anything about the Federalist Papers. It's all about the Federalist Papers. But here's what he brings up: an interesting question. He said, we've never had a case that challenged fingerprinting upon booking as a reasonable means. It's never been challenged. We just sort of accepted it over the decades as a regular practice. However, he said, you know what? At least with fingerprints, it is used exclusively for the identification of the person arrested, not as a backdoor to solving cold case crimes. Solving cold case crimes is great, but we still have a constitution.
There's not a fingerprint database that if my fingerprints show up somewhere else, they can come and find me?
Yeah, there is. And it takes 27 minutes to check that nationally. However, this other thing, the DNA, it takes at least 3 or 4 months. This is a great technological but terrible constitutional decision.
So Scalia agrees with Ginsburg and Sonia Sotomayor, and who's the other big lib over there? Who am I missing?
Elena Kagan.
Elena Kagan.
And not only does he agree with all of those libs, I think he agrees with the original intent of the United States Constitution. This is a bad decision, not for the efficiency of solving crime, but I think for more importantly, as he says it better than me, for the Fourth Amendment protections of our Constitution.
So, in other words, the second best radio talk show host in Missouri agrees with Antonin Scalia.
I do that sometimes.
Ladies and gentlemen, that's Scott Sherman. Who's your sponsor, Scott Sherman?
St. Louis Home Retention Group. You know, they're not going to take any DNA samples or fingerprints. All they're going to do is save your house and save you money. I just heard this week that interest rates are going up on mortgages, but the federal programs that are in place for what happened to us during the mortgage crisis, which caused our values to go down in the first place, are still in place. And you folks may well be eligible for that. St. Louis Home Retention Group knows all of those programs, and they can get you set up and save you big money. They did it for me. They've done it for lots of people. Give them a call, 636-527-5121, 636-527-5121, or stlouishomeretentiongroup.com.